Right, good afternoon, everybody. This is the final webinar, actually, that we're going to be doing for 2021. I can't remember. It seems incredibly how quickly we've gone through, but I can't remember how many sessions we've done throughout 2021. But there's been a few. I guess if we do 4 a quarter, do 6 a quarter, and we've done 4 quarters, that must be 36 webinars. So yeah, simple maths. Thank you very much for joining. This is, as I say, the final session of the day. We're going to focus on one of our favourite topics and the one which always generates the most interest and discussion, which is all around data privacy. And it's a piece of legislation that absolutely does not want to stay still. It's continued to grow and change even since our last webinar in September on this topic. So just to recap for those of you who are joining for the first time, all our recordings are, all the sessions that we do are recorded, and the recordings will be put on the company website, on the riskivolves.event website for you to look at later. There'll also be a link that's sent out to you. We haven't got any handouts for this session, but we do of course have the questions, the questions box on the GoToWebinar control panel. Please ask lots of questions. Anna and Andy are very keen to answer as many as they possibly can. Probably the harder the better. That's really good. End of a long day. It has been an incredible year from a perspective of legislation. As I mentioned, it has not stood still, and I've just put together a few discussion points that I thought we'd go through with Anna and Andy. So we started, I guess, when was it? Summer. The Information Commissioner went out for consultation on some proposed changes to the legislation. So Anna, I mean, that feels a long time ago that we sat on a call going through reams of paperwork on proposed changes. Do you want to just recap where they are and where we're sitting in terms of what's happened to that consultation change?
Oh, I can do. So obviously this came about because we left the EU earlier this year. So the government have said, actually, now we've left the EU, we've got an opportunity to re-look at the GDPR. While we adopted it into UK law, you know, they've thought, you know what, let's have a look at it. So they've been consulting on a number of changes. I think that closed last month, didn't it, Helen?
Yes.
You know, and it's quite interesting. There's, you know, they're looking literally at the whole GDPR and looking at the kind of things that they might want to change. So things like, you know, the requirement to have what's called a record of processing activity, the requirement to have a data protection officer, you know, some of the real fundamentals. So I think it's going to be really, really interesting to follow that and see where we end up. Some of the changes I think are, you know, I think that they could be quite interesting and quite useful. Some of them, yeah, one to watch.
One to watch, completely agree. And what we've also seen is consultation not just from the ICO, but from DCMS as well, Department for Culture, Media and Sport, is it? Oh,
yes.
DCMS,
yeah.
One of others, we know the acronym, but you're not quite sure what it means. So again, much more consultation, but that's also around the international relationships, isn't it? With the likes
Yes.
of Singapore, Australia, India and the US, and whether we can have some sort of adequacy agreement with the US, which seems to fly in the face of an adequacy agreement with the EU.
I think we have to tread very carefully there. I think, you know, we've been granted adequacy from the EU for, what is it, 4 years? And I think if we then start to grant adequacy, Andy, I can see you nodding there. I think if we start to grant adequacy to the US when the EU is so against it, I think we need to tread very, very carefully there. Certainly one to watch.
Definitely. And on the consultations, one of the things that Risk Evolves has done is we have fed back. It's an open consultation, so anybody can put their thoughts and feelings in the consultation feedback template, which comes out from the Information Commissioner's Office and also from DCMS. And Risk Evolves has fed back on both of them. I think from our perspective, we work with predominantly smaller businesses, just understanding how some of these changes are going to be brought into law and how we manage them as small businesses is a real challenge. I mean, Andy, I don't know what you see in that space, what your thoughts are in that space.
Yeah, I mean, obviously we help a lot of clients, don't we, on critical friend arrangements to try and do the finding out and the information for them. And there's more and more stuff that's hitting us, and we're doing this day in and day out effectively as a full-time job and finding it difficult to keep up with some of the changes. So what it's like for those small businesses that may have somebody that's doing it part-time is just a hell of a challenge. And as I said, you've got the consultation coming through, but other aspects have already hit, like the US Privacy Shield being revoked and the new EU or the new standard contractual clauses, of all things that have been hitting businesses. Some of them probably aren't even geared up to understand what they mean. Then you add in what's changed with Brexit. Then you add in the fact there's a pandemic and we want to test people. The list goes on and on and on. And obviously we're doing our best to keep up with that and help a lot of clients to try and keep on top of some of those things. But it's a big challenge, yeah, and there's no doubt it's a big challenge. And
yeah,
we'll continue.
absolutely. And absolutely correct, it's going to continue to be a challenge because we're also expecting changes, not just in the Data Protection Act, but also expecting changes as well at some point in the other piece of legislation, the Privacy Electronic Communications Regulation. Now that's been promised from an EU perspective since, what, 2018, hasn't it? We were expecting it to come in the same month as the GDPR came in. But it's actually very, very quiet, isn't it? And that's the one that's a piece of legislation that governs how we use things like websites and email marketing and cookie policies on websites. But we'll come on to that a little bit later, I think, because we're going to talk about, well, we'll come on to that and we'll talk about the F word. Anna, you were super geek. You were there on the Supreme Court's webinar earlier this month, waiting for the outcome of the Lloyd versus Google case, which I have to say is geek heaven for you, I know. What happened?
Absolutely. So what was Lloyd versus Google? So Lloyd, he was, I think, the ex-managing director of Which, and he took to the courts to challenge the use by Apple of Google tracking on Apple devices. And it was really interesting. It went all the way through the courts from kind of Crown, you know, and all the way up to the Supreme Court, and each court was disagreeing with the other one, and you know, the final chapter essentially was that the Supreme Court's decision just last month, and you know, it was going to be, either way, it was going to be massive, because if they had found in favour of Lloyd and against Google, it would have been a huge case law, and would have had ripples across the industry for the use of kind of device tracking and cookies and those kind of things. It actually came out in favour of Google, so Lloyd did not win his case, and I think that's quite interesting. I mean, gosh, we've only got a few minutes to talk, so I can't go into too much, but essentially, you know, this case was brought under the previous Data Protection Act, the Data Protection Act 1998, which means that there was not as much, what's the word? There was not as much control in place around tracking and those kind of things. Gosh, and you know, Data Protection Act 1998 was brought out, you know, when we didn't have these kind of technologies. So they were essentially assessing new technologies using an old law. So I think it would be really interesting to see this case challenged against the GDPR to see if the outcome would have been different. Yeah, really interesting case.
And certainly that's what the judge suggested, wasn't it? That they bring it back to court. If there's another case, they're going to bring it back to court under the 2018 legislation. Brilliant, yeah. So we're obviously watching. One of the things that we do at Risk Evolves is we look to see what's happening with case law and what's going on. We've had some interesting letters that have come in via our clients though, Andy, haven't we? Loss of control and distress claims. Do you want to touch on what we've been seeing there?
Yeah, I mean, obviously, in terms of the principles of GDPR, if you're in control of the data, it's not your data, so therefore anything you do with that data has to be declared. And where you then, as an organisation, then start to share it with other organisations, you are then responsible for what they can do with the data. And where those other organisations may then start to use the data for other purposes than what were declared by you to the data subject, then it's quite clear there's a loss of control. So this has really become apparent with cookies. Cookies have it's always been around, but it's being more enforced now. It's a hot topic whereby cookies that are non-essential to your website, things like Google Analytics, any form of analytics, advertising, any that need consent. And the problem with most websites is there's no explicit consent being sought. So from an organisation, I've spoken to many a client around, well, you're using Google Analytics, but you're not getting consent for it, and the organisation saying, well, we're not actually doing anything wrong with that data, but it comes back to, it's not what you're doing with the data, it's what Google are then able to do with the data, and that's where this loss of control then comes into play. So there's been a letter downloaded clearly available online. We've seen it 4 times now, I think, where our clients have been sent a letter basically claiming compensation. It's 4 pages long, and there's nothing that the organisation can actually defend against, where if they've not got consent for these kind of cookies and they've shared information with the likes of Google Analytics, they can't actually turn around and say that they're still in control of the data. So in terms of what that amount, it came out through the Lloyd's Google, didn't it? The distress that's caused is the justification for how much. But these letters are pretty much claiming an arbitrary amount of £750. So if you're hit with this as an organisation, it's a case of, well, what do? Do you try and defend it and it goes through the local courts for them to claim against you for distress, or do you pay and keep quiet? Ultimately, though, you've got to correct the problem, which is sorting out any sharing of data or cookie consent and those kind of things. So yeah, it's definitely a hot topic, and we're seeing more and more.
And we are seeing more of it. And for anybody that wants to find out a little bit more around the topic that Andy was talking about, their cookies on websites, Anna and I did a whole half hour on cookies on websites on the September webinar. So again, that's on the website, on our website, the Risk Evolves website, if you want to download it. Distress claims, though, is not all bad news, because there was a case that went through the courts a couple of weeks ago, which a judge threw out. We like judges that throw some of these cases out, don't we? Not all of them, but some of them. Anna, do you want to just give an update on what happened there?
Yeah, so it's quite interesting, this one, because, you know, as Andy's been saying, you know, people have this concern around, you know, the loss of control of data, you know, that they're not able to understand what's been happening with it. And this case was quite interesting. I believe it was a father in relation to his son's data, the judge actually just said, essentially, you know, you're just trying it on. There was actually genuinely no loss of control and no distress. So what they, you know, they couldn't actually demonstrate that there'd been this distress. And the judge was just really quite pragmatic and sensible and said, you can't demonstrate that there was any distress. I don't believe there is any distress, and therefore I'm going to throw it out. And I think it's reminiscent of a case that came to court a long number of years ago now, in a completely different sector, in the water safety sector, where you know, there'd been an accident at a beach, and somebody had fallen off something into the water, and the judge, and they were trying to blame the council for them falling off the rock into the water, and the judge went, no, you knew the rock was slippy. And I think it, you know, it was quite interesting for me. This is the first case in terms of loss of control and distress that a judge has actually taken this very pragmatic view and said, you couldn't demonstrate what that loss of control and that distress was, so I'm not hearing it.
And I saw another one as well earlier this week, not dissimilar. So this was the claimant hadn't paid an invoice. The person that hadn't received the payment of the invoice put it in the hands of a solicitor. The solicitor wrote a letter and accidentally sent the letter to the wrong person, which included details of the invoice. The solicitor very quickly informed the person that he had accidentally received it. They deleted it. And it was all closed within literally a very, very short space of time. Unfortunately, the solicitor was taken to court by the claimant, saying that he was distressed that his financial situation had been made visible to another person. And once again, the judge threw it out and said there was no personal information contained within the letter. The letter itself was not of a sufficient detailed level that would cause sufficient distress. And because the letter had been recovered so quickly and had not been opened by the person that had been sent to incorrectly, again, the judge threw it out, saying there was not sufficient claim for distress. So if we do end up in court, and clearly we don't want to get people into court, there are remedies. But Andy, sorry, interrupt you.
Yeah, the fact we're seeing this kickback is important, because we've been chatting for a while that as soon as a claim is made and it is paid out through the courts, that almost sets the precedent that this is now acceptable, and whether that's at £500, then you'd start getting the realms, this could be another PPI kind of claim, because people can just start throwing this thing out willy-nilly or to multiple organisations just to see what they can get. And the fact it's being viewed on a case-by-case basis and sensible decisions being made on the back of it, I think it's really important.
Definitely, definitely. Don't forget to ask questions, pop them into the chat box, pop them into the question box. We'll certainly see whether we can answer anything as we go through. We've spoken very much about things that have been thrown out, but the F word, fines. Commissioner's been quite busy in this space, hasn't she, Anna? And I say she, but we've got some changes going on there as well, haven't we? But where is Mrs. Denham been busy? So
Mrs. Denham it's been quite interesting actually, watching the the development of fines since GDPR came in. Well, oh my gosh, it's 3.5 years ago. Can't believe it. And actually, she's been very, very quiet. But suddenly, in this last kind of few months, we've started to see a little bit more activity. So we had very, very recently those of you who remember the large data breach a couple of years ago with the New Year's honours list. Unfortunately, the Cabinet Office publicised on their website not just the list of names of those who'd been honoured, but all their contact details as well, which actually is really, really significant, because you've got, you know, the likes of MI5 and MI6, you've got security forces, you know, you've got the police, and you know, this was significant. And just recently, the ICO have fined the Cabinet Office £500,000. Quite an interesting one there. I think one of the most fascinating ones for me is that I think we all kind of think about fining in terms of, you know, data breaches and what happens if the data falls into the wrong hands. For GDPR, the ability to fine under GDPR goes a lot wider than that. And I've seen a really, really interesting one just at the end of October, where there was a charity in Scotland that were fined under, I'm going to get geeky for a second, Article 32 of the GDPR, which is actually around the security of processing. So this is all the elements that you have around, you know, your infrastructure security, those kind of things, firewalls, all those technical pieces. And the organisation was fined. There was a data breach that happened, but it was as a result of a failure of these technical measures that they had in place, and the fact that they hadn't had strong enough technical measures to protect the data. Now, the data was sensitive data. It wasn't just your normal level of personal data. So where you're processing sensitive data, you've got a higher level of legal obligation anyway. So that, for me, is probably one of the most interesting ones, to see fines going a little bit wider from the traditional data breach fine. So that you know, that I think that starts to send quite an interesting message from the ICO as an organisation, that they're starting to really look a little bit deeper when something happens, and look at how you're applying all elements of the GDPR to the data that you're processing.
Absolutely, absolutely. Andy, any comment on fines?
Yeah, and as I say, most of the fines are still in the realms of marketing and marketing to people where you don't have approval, or telephoning people on the tele. So we're still seeing loads and loads of those. But as you say, Anna, those two cases in particular are interesting, because obviously people recognise, I mean, if you think what's changed since May 2018, it's significant. But what has definitely changed since May 2018 is the sophistication and the kinds of security breaches or attacks that are happening. So therefore, if you're the data controller, you're responsible for security of the data through simply sending something in an email. And it was interesting, both those cases, it was linked to emails and attachments and information being provided in emails. So, but yeah, I mean, there's also been other enforcements around organisations that haven't in place, some of the processing registers and everything been referred. So the ICO has still been very quiet. I think we know across Europe we see a lot more fines being issued. France in particular, Spain has been very busy as well. We're even seeing quite a lot more activity in Ireland than we do within the UK as well. But I think that the important thing is, if we're doing things correctly, then we can stand behind that whatever penalty comes at us is going to be offset by the actions we've taken. So if you've not revisited what you've done for some time, probably now's the time to start thinking about it.
Absolutely. Now's a really good time to do it, absolutely. So that's one of the things that is key, isn't it? What you did in 2018, you can't just ignore. You have to go back and reassess and make sure that that is still relevant and accurate for the current workplace. Absolutely. Which brings us quite nicely onto SARS. We've been busy, team, haven't we, supporting customers with SARS this year. They've been complex. We've had some really complex ones that we've supported. I mean, I know both of you have been very busy with some of them. Andy, do you want to just share some thoughts and best practice on how to manage a subject access request?
Again, if we've done our jobs properly and only actually holding the data that we need to, then the job becomes a lot easier. But all too often we're seeing these challenges come through where organisations perhaps haven't quite taken the principles of data retention into their email accounts, and the number of times that we're then doing when we get the subject access request, obviously they're entitled to see the information about them contained in emails, which is all well and good, but you have to go through the emails to find out what's contained there, and it's pretty soul destroying when you're getting in the realms of tens of thousands of emails that you need to go through, and some of these that clearly shouldn't have been kept in the first place, because it would be, Helen, let's meet for a coffee at 10 o'clock on Tuesday, and it takes time to do it. And obviously principles aren't 30 days free of charge. If you've got 10, 20, 30,000 records to go through, which then need to be considered and redacted because you can only share information about the person, they become a challenge. But the interesting thing that and certainly the ones I've seen, they all tend to be, there's another purpose behind them. So I wouldn't say necessarily malicious intent, but it's usually an intent that perhaps it's to do with a staff issue or an ex-member of staff that may have left. So pretty much that's the areas that we're seeing the biggest challenge. And I guess for most smaller businesses, it's in the areas of staff details and records where they've got their biggest GDPR compliance issues in the first place. But, so the more and more people know.
Definitely. Anna, what would you add on that?
Yeah, it's really interesting. I agree with Andy there. The majority that I've been working on recently, you know, are for organisations where a relationship's broken down with an employee, and you know, I'm talking as somebody who's done, you know, in excess of 250 stars, and you know, nobody puts in a star unless, you know, that's happy. There's generally something that they're looking for, whether that's a smoking gun or something like that. And you know, Helen, you said at the beginning that we've had some really, really complex ones, and we really, really have. And I think one of the certainly the most interesting things that I've been deep diving into this year is the legal exemptions. People can ask for a subject access request, but there are, you know, just because they ask, it doesn't mean say that data is absolutely disclosable. So had a client very recently who, you know, there was just this, oh my gosh, you know, they can't have all this information. I'm like, no, it's absolutely fine. Actually, you know, there's the right to ask, but there's lots and lots of exemptions at play. So I think applying the exemptions has been quite challenging this year. And I think one of the other challenges that I've seen, and certainly top tips, guys and girls, for you, is make sure you've got a really great relationship with your IT provider, because they will be crucial in you processing a subject access request quickly. Make sure they understand, and make sure you practice it. If you've never had a subject access request, brilliant, you will get one at some point, I'm sure. And the last thing you want to be doing is, once that 30-day clock is ticking, is going, oh my gosh, what do we do? So practice one. You know, practice it using your own data. It doesn't have to be another employee. You know, do one using your own data. Talk to your IT providers, or you know, your internal IT team. Make sure if you're on Office 365 that they know how to use something called e-discovery. The e-discovery search is something that's so powerful within the Microsoft 365 product. Essentially just allows you to write a query that pretty much says, you know, I want all the data between these dates and these dates, you know, between these people and these people. It's really, really powerful. So if you've never done it, practice one. You know, my grandma used to say, practice makes perfect. It does.
And actually that goes back to the session that we had earlier today with Mandy, when we were talking about IT providers and what to look for in a good IT provider. And we would always say, do they actually know what the GDPR is? Do they know what data privacy is? Because as you say, Anna, we've gone to some IT providers and they've gone, come again, excuse me, not heard that?
Yeah.
That's not a great starting point when your clock is ticking at 30 days.
No. Get practicing, guys and girls. Make sure you note down where all your data is. Oh, here's a funny thing though. I was doing a SAR quite recently, and Andy, you mentioned about data retention. I had to review a number of faxes from 1993. So yeah, so guys, if you know, if you've got faxes that you've retained, it might be a really good time to have a look at those.
So what does 2022 look like? Here we are sitting on the eve of a new year. We've got a new commissioner coming along. Any views on who our new commissioner is and what do we think he's going to bring to the party?
Mr. John Edwards, coming in from New Zealand, I believe. So I think doesn't he? So Elizabeth Denham left us last week, was it? I think it was last week. week before. So John Edwards joins us, on the 3rd of January. So we're in a little bit of a kind of, vacuum, that kind of air gap at the moment. One's left, we're waiting for the other one to come in. What's he going to bring? It's going to be really interesting. I think one of the most interesting points about John Edwards, he's not a fan of social media. That is for sure. So I think it will be really interesting to see, Andy, you mentioned that Ireland are, the regulator there are very, very active, and, they're particularly active against, the large social media organisations. So, will John Edwards start to join that wagon with the Irish regulator? It's going to be really interesting.
We find the whole space really interesting. I don't know anyone was watching the BBC News last night. I picked up on the article that the BBC News did on the metaverse, and there was a comment around how that's going to impact our privacy. Now, emerging technologies, exciting space on all sorts of different levels, but clearly there's a privacy impact. Andy, don't know whether you've got any thoughts on that?
Yeah, I mean, it goes back. If you go, I remember going to conferences, data privacy conferences in 2017, where you've got these big IT providers. It's obvious who they will be, and there's this trade-off around actually morally to do some. There's this trade-off around morally, is this the right thing to be doing anyway? Let alone the data privacy issues that come through with it. But it's one of those that I look at stuff like that and think, well, as a civilization, we've tended to manage quite successfully without having all of these avatars and this wonderful new technology. So I may be a dinosaur in some of my thoughts with this, but the reality is that if you turn around and take the metaverse, which is obviously Meta through Facebook, if you like, it's a free service. And, I was brought up on those principles that nothing in life comes for free. So somebody's making money out of this. So this is another means of, they must be generating money somewhere. And we know that's been perhaps through advertising campaigns. But when we're going to start to have video meetings with avatars in the room rather than actually, it's not something that I'm filled with joy about. But hey, we'll see what comes.
We'll bring you across the line, Andy. It's all going to be fine. You're just being far too cautious. But it is an interesting space, isn't it? Because we were already working with a couple of companies in this space, and some of the challenges they're seeing and how they ensure that they adhere to the current GDPR is absolutely challenging. And equally, we all know that we don't want businesses to be stopped from doing things unnecessarily, but there's that balance, isn't there? There's that trade-off between what we can do for making sure with the individuals and then also balancing it with commercial need.
And I think what's interesting with the 2022 question as well, Helen, is that we've got these emerging technologies that are now coming into play 4, 5, 6 years after the GDPR started being thought about and written. So, I'm certainly working on pieces of work where I'm trying to apply the legal framework into new technologies, and it's already starting to become quite interesting how we apply those laws to those new technologies that have emerged since that law was written. So it's amazing how quickly things change and develop.
So we're at the bottom of the half hour, really quick canter through. As a team, we always think 30 minutes, we're going to be how are we going to fill 30 minutes? And we get to the end of 30 minutes, we could have spoken for another 30 minutes. As you can tell, it's a topic that we are really passionate about. I bring the webinar to a close. You will receive a short questionnaire asking feedback. Please be honest with your feedback. If you found it useful, then please say so. If you think we can improve in areas, please let us know as well. Also take the opportunity to point us towards any topics that you'd like us to discuss in the future. I think it goes without saying that GDPR, data privacy, etc., will remain on our agenda, and we will probably do a review of the basics of GDPR for anybody that's coming into this thinking, what on earth are they talking about? So we'll do one of those in the new year as well. Otherwise, a date for your diary for next year is the 17th of March, when we will be doing another set of 6 webinars covering the 6 different services that Risk Evolves can offer you. I guess, I can't believe I'm saying this on the 9th of December, it just remains for me to say thank you to Anna and Andy for joining us for yet another canter through the GDPR, and to wish everybody a happy Christmas. So thank you very much, guys. Thank you.
See you later.
Thanks, everyone. Bye.